On August 19, 1914, the German 28th Regiment of Pioneers, under the orders of Colonel Schonemann, entered the Belgian village of Aden, a town of 7,800. A panic broke out when a single rifle shot was heard as the German troops began to defile through the streets of the town. In response, the German soldiers began to panic and fire indiscriminately into the Belgian village, thus initiating what would become known as the Martyrdom of Aden. The following day, the German soldiers spread themselves throughout the town, driving all of the population into the streets and forcing women and children to march to a meadow and look on as scores of the village men were swiftly executed. In total, 300 Belgians were massacred in Aden, and about 300 houses were burnt in 2 localities, thus signifying not only an act of ferocity and cruelty by the German troops, but also an utter disregard for the international law and the foundations of Belgian neutrality established at the Fifth Convention by The Hague. One would expect that the atrocities committed by the 28th Regiment of Pioneers in Aden would result in the immediate pursuit of legal justice at the conclusion of the First World War. Yet, the unprecedented degree of carnage and disregard for human life, facilitated by an unprecedented war, resulted in the need to formulate an unprecedented judicial system. After nearly a year and a half of negotiations between Germany and the Allied governments, the Leipzig War Trials commenced on May 23, 1921, led by a special tribunal that was presided over by judges from each of the major Allied powers. Analyzing the Leipzig War Trials suggests that the judicial proceedings set an important legal precedent prosecuting violations of international law, particularly related to crimes committed in a wartime setting. Conversely, the findings of the court, which found only 6 individuals guilty and provided rather mild punishments, was a legal debacle that failed to punish any orchestrators of the most severe atrocities committed in Belgium and throughout Europe. Before exploring the testimony, evidence, and findings of the Leipzig trial, it is critical to understand the development and structure of the court. The Treaty of Versailles, or more specifically Articles 227 through 230, largely dealt with the war criminals' trials. In short, Article 227 established the aforementioned special tribunal, and Article 228 obliged the German government to hand over those accused of violating the law and customs of war. In total, the Allied governments had originally wanted at least 1,590 German suspects to be extradited on war crime charges, which included prominent German figures such as former Chancellor Bethmann Hollweg. However, the Germans protested that the political conditions following the war were so unsettling that it was impracticable for the government to arrest all the men whose names were on the list, and especially those who were national heroes to the German public. As a result, the Allies agreed to an arrangement to try a selected number of cases before the German Supreme Court in Leipzig. With regard to the Leipzig trial, British writer and lawyer Claude Mullins noted in his commentary that, quote, "The war criminals trial of 1921 will never be understood unless it is realized that it was decided that a war criminals trial should be a trial in the fullest sense of the word," close quote. In essence, the aim of the special tribunal was not to conduct a legal proceeding dictated by popular passions that demanded wholesale convictions and probable lifelong sentences, but to rather conduct an experimental and carefully planned trial on the assumption that the ordinary principles of criminal courts would be observed. Due to the lengthy and highly contested legal negotiations, the British, French, and Belgians were only able to prosecute a handful of individuals at the Leipzig trial. British accusations were largely concerned with U-boat warfare and the alleged mistreatment of soldiers. The French focused on incidents of willful neglect in German POW camps, and the Belgians sought to prosecute those responsible for the ill treatment of prisoners and those deemed responsible for the massacre at Andenne. The sole German individual that was prosecuted by the Belgians was Max Ramdor, who was accused of being guilty of numerous acts of cruelty on Belgian children at Grammont between November 1917 and February 1918. Ramdor, a former law student in Leipzig and an officer in the German secret military police, was specifically accused of confining children in cells which were unfit for their reception, striking and pushing the children's heads into buckets filled with water as punishment, and, quote, inflicting numerous other cruelties upon them, close quote. Despite testimony from numerous witnesses, the court found the evidence to be so contradictory and unsatisfactory that it could not convict the accused of any crime. The court noted, quote, at their youthful age, the witnesses are not sufficiently unbiased to realize that the accused merely fulfilled his duty, close quote. In sum, the inherent improbabilities and the inconsistent evidence given by over a dozen children led to the acquittal of Ramdor on all charges. In response, the Belgian delegation departed Leipzig in outrage, declaring the proceedings to be a, quote, travesty of justice, close quote. The remaining Belgian cases, including the Andenne massacre, thus fell by default. The failed prosecution of Ramdor signifies the complexities of the Leipzig trial of 1921. While there is little doubt that the actions of Ramdor caused real suffering to the children he was accused of exploiting, and despite the fact that some of the supposed inconsistencies complained of in the judgment can be considered rather trivial, the case held up to the principle of criminal court in which one can only be found guilty if the evidence warrants such a decision. The immediate impression of the trial, from the perspectives of both the Allied powers and the Germans, was that the judicial proceedings were largely a legal failure. German nationals could not rationalize one being found legally culpable for a crime that was committed under the orders of a superior officer. Moreover, the general reaction from the Allied powers was that the punishments for the 6 individuals found guilty were essentially a slap on the wrist. As a result, no further charges would be sought by the Allied powers, thus ending the judicial experiment. While it is hard to argue against the claim that the Leipzig trials were a complete failure in the short term, especially considering the atrocities committed in Belgium, it is important to note the long-term legacy of the judicial proceedings. In essence, the Leipzig trials set a legal precedent of prosecuting those who have violated international law. Such a precedent would be of extreme importance in the legal pursuit of those who violated international law throughout World War II, or more particularly, the conglomerate of Nazis that would be tried in the Nuremberg trials and other analogous post-war trials.